morning.
So I appear today on behalf of all three claimants. The defendants have been notified of this hearing, but have indicated that they do not wish to attend today. And for your information, all defendants have been served, and all have acknowledged service apart from the 1st, 13th and 17th. And as you may be aware, this case is part of a wider series of cases. And in January of 2024, there will be a trial by direction of Mr. Justice Mellor, which will essentially determine the question of whether Dr. Wright is Satoshi Nakamoto, the creator of Bitcoin. But fortunately, the only issue on this appeal is much narrower, and we submit the question is it arguable that the Bitcoin file format, as set out in Schedule 2 to the particulars of claim, has been sufficiently recorded in writing or otherwise, such that the requirements of subsection 3.3 of the Copyright Designs and Patents Act have been met? In other words, in the jargon of copyright, have the so-called fixation requirements for copyright been met? And as you may appreciate, the questions raised by the judgment in this case have considerable interest not just to the parties, but to the wider information technology industry. Because, as you will appreciate, the modern world relies on data and computer programs that are stored in electronic files, and the industry is interested in how the requirement for fixation may be met in the case of file formats. May I begin by just reminding you of the provisions of the Act. And what I've done in the bundle of authorities is attempted to include every authority, but unless it will help you, I'm going to take you to the skeleton where I set out relevant extracts, because I hope that will save time. But what I've attempted to do in the bundle of authorities is to give you a comprehensive set of documents which you can refer to in due course as necessary. So I've set out the provisions, the relevant provisions of the Act, under paragraph 9 of our skeleton, which is at page 3, internal of the skeleton, page 21 of the bundle. And these are very familiar provisions, but particularly important. Section 1 says that copyright's a property right which subsists in accordance with this part in certain descriptions of work, one of which is original literary work. Section 3 defines what a literary work at least includes. It means any work other than a dramatic or musical work which is written, spoken or sung, and accordingly includes, and then there's a list of items. Subsection 2 is a fixation requirement. Yes, in my opening I said subsection 3.3. I should have said subsection 3.2, of course. It doesn't subsist until it's recorded in writing or otherwise. And then subsection 3 makes it clear that it's immaterial whether the recording of the work is by or with the permission of the author. And where it is not recorded by the author, nothing affects the question of subsistence of copyright. So fixation is a condition of copyright protection. And conceptually, as you will have seen, it consists of moving a work which exists within the head of the creator into some fixed format. And in copyright, the work is that abstract work that exists, and it's distinguished from the fixation of the work, which is the physical form in which it manifests itself. So I compose, I'm not a poet, but if I compose a poem lying in bed at night, that is the work. It exists in my head. It becomes fixed if and when I write it down.
Yes, so we need to distinguish between what the civil lawyers wonderfully call the corpus mysticum and the corpus mechanicum.
Yes, yes. So fixation is a technical requirement. Now, if one looks further down in the skeleton, section 178 gives a wide definition of writing. It includes any form of notation or code, very, very broadly specified. That I've set it out in paragraph 11 of our skeleton, a broad definition of writing in section 178. Now, next, could I take you to Schedule 2 of the particulars of claim, the work in question? And we've set that out separately for convenience because it's been deleted in the current version of the particulars of claim in tab 8 of our core bundle. And you will see over the course of a number of pages, what's been set out is what's called a field. That, in the jargon of computer software, is a place where a particular form of data or information will be stored, the size, the number of bytes, the amount of space that field occupies in the file, and then a brief description of what will be placed in those particular locations. You don't need to look at the details, but it carries on for a number of pages. Essentially, at the top, there's the block structure, which consists of a header, something called the VTX number, which is the number of transactions, and then the details of the transactions. And then separately, at paragraph 3, we've set out what the structure of the block header is. And then later, we set out the structure of what a transaction will consist of. And there are two types of transactions, what we call a normal transaction and a coin-based transaction. Now, by way of back...
So I understand two different types of transactions, at least to some extent. What is then done is to set out general structure of a transaction, okay, and then we have normal transactions and coin-based transactions. And then distinguishing between the structure of an input and structure of an output.
Yes.
Can you just explain that?
Let me try to explain. So you have the block header, which is standard to all blocks, the number of transactions, and then the block contains details of transactions. Perhaps if I can just step back a moment and explain what is happening here. Since January 2009, when the Bitcoin system was launched, a new block has been added to what's called the blockchain in this format about every 10 minutes by a process known as mining for Bitcoin. And what the process consists of is computer systems throughout the world competing to solve a mathematical puzzle. In fact, it's more akin to a guessing game than a puzzle, but computer systems throughout the world compete. And the winning computer system, the one who solves the puzzle first, is allowed to do two things. It can propagate to the rest of the computer network a new block. It will say, I have found a solution to the puzzle, and I'm now propagating to you all a new block. Please add it to the blockchain. And a new block is as described here. And the reward that the winner gets for that is that they're entitled to allocate to themselves a certain amount of Bitcoin, which is recorded in the new block. And in addition to awarding themselves a certain amount of Bitcoin, the block also includes details of other transactions relating to Bitcoin that have taken place previously but have not been recorded in another block. And so, by convention, the first transaction in a block is a transaction whereby the computer system that won the competition awards itself to a particular, what's called a Bitcoin address, a certain amount of Bitcoin. That's the reward. And that's called a coin-based transaction. A transaction in the terminology of Bitcoin is when Bitcoin is moved from one address to another address. in the Bitcoin system, individuals don't say who they are. They are identified by a fairly complex process, but essentially they are given, in effect, an address. And that address will be their address, and I can request you to send a certain amount of Bitcoin to that address, and that would be called a transaction. And all transactions have outputs and inputs, except a coin-based transaction. An output is when someone sends me some Bitcoin from this address to that address. An input is when I receive a certain amount of Bitcoin. It's a little bit more complicated than that because transactions can be subject to conditions themselves. But broadly speaking, the idea is that the Bitcoin blockchain is a ledger of all transactions in Bitcoin that have taken place. It's an ever-growing ledger with each block building on the previous block. And by including what's called a hash of the previous block in the blockchain, a subsequent block links itself to the previous block, and the previous block links itself to the block before that. And the system is devised so that, for practical purposes, any attempt to change the contents of any block in the blockchain will fail because the checks performed by nodes and other people on the blockchain will indicate that somebody's attempted to tamper with it. So that's a long description, but the short point is that each block has to be in this particular format in order to be a valid block. And of course, it being in that format enables the other nodes, the other people mining for Bitcoin, to review what other nodes have done. It also enables people to write software which will examine the contents of the blockchain. And it also, in fact, as we'll come to in a moment, enables other people to write other compatible implementations of the software which underlies the blockchain. So the heart of the blockchain are two things: some software, which is run on computer systems distributed throughout the world, and the Bitcoin blockchain, which is this ever-growing ledger recording coins issued, if you like, to miners, and all transactions. And just by way of background, not relevant to this, originally a miner got 50 Bitcoin awarded to them. Every 4 years, the reward gets halved, and at the present time, it's 6.25 Bitcoin. That's just background. So the blockchain is central to the whole Bitcoin system. It is the ledger where all Bitcoin transactions have been recorded. For practical purposes, it's unchangeable, because any attempt to tamper with it will be detected, because what's called the hash of a particular block will change, and software can check the hash of a particular block with what the subsequent block thinks the hash is, and if there's a mismatch, it will say, there's something gone wrong here, this can't be right, and reject it. So what the schedule does is set out what the format of a Bitcoin block must be. It requires certain details and specific items of information to be stored in specific places in a particular format. And that's what the schedule is referring to. Now, another feature of the Bitcoin blockchain, which was central to the judge's reasoning, is that it is correct to say that if one looks at a Bitcoin block, imagine a computer file, using an appropriate computer program or some means of digging into electronic files, one will not find within the blockchain some textual description of what that particular part of the block is. So for example, if one looks at page 125 of the bundle, the structure of a block header, one will see that the first 4 bytes of the block header consist of a version number. It will be a number stored in what's called 32-bit unsigned form in little endian. That's just a technical term to do with the order in which particular bytes are stored. Technical, but it doesn't matter for this purpose. You will see a number there if you've got the appropriate software. There will not be a piece of text just preceding it which says this is the version number. And likewise, the next 32 bytes will be what's called the double hash of the previous block header. That will be there, and the software can look at it and compare it with the previous block. There will not be something that says, by the way, the next 32 bytes are the hash of the previous block. Just is no description in that sense of what is there. Although what is there is, in a sense, is there, and it's there for good, and it has to be there in that particular format. And as the judge noted in his judgment, the fact that the blockchain has been written or developed in this way is not a surprise. One objective of someone creating a new file format for storage of data or other information maybe, not necessarily is, but in some cases, someone creating a file format may want to keep the file compact, as short as possible, not include any unnecessary information. And the reason for that is the shorter it is, the easier it will be to transmit the file, the data, from one person to another, because you're not transmitting any unnecessary material, only the material that is important. And the second thing is, and related to that, is it may help the system run more efficiently and more quickly. Now with Bitcoin, it must have been envisaged, or at least hoped, that the system would develop to the point where it is now, where there were many, many hundreds of thousands of blocks, with each block containing details of very many transactions. And so to include within every block some sort of description or notation of what each field is would be hugely wasteful of storage space, because that notation would be replicated in every block hundreds of thousands of times. And people wishing to move or take a copy of the blockchain because they wish to become a mining node, or wish to study it because they wish to be an exchange, would be moving data, descriptions, which would be irrelevant to them and hugely wasteful of space. But the judge in our submission held effectively that it was this lack of content describing what was in the file format was fatal to the contention that the Bitcoin file format had been fixed. Content indicating structure. Now, the oddity of that result is that a space-inefficient file format, which includes some form of description for each field, could potentially be protected by copyright because it does have some content indicating its structure. But the same format, precisely the same structure, but without that embedded description, would not be protected. And we respectfully say that the judge was simply wrong in that regard. And what I propose to do, subject to any questions and observations you may have, is to summarize our case on this appeal in 5 propositions or reasons. And then I will endeavor to elaborate upon them as necessary. And of course, if at any point I'm going too slowly because it's material you've read, no doubt you will hurry me up. Now, our first proposition is that fixation is not an onerous requirement. It merely means, we say, that the work in question has moved from something that exists purely in the mind of the creator into a tangible form. And there will be no dispute that a tangible form can be an electronic form. You've seen the wide definition of writing. And of course, if that were not the case, a book written on a word processor would not be fixed itself. There's no doubt that electronic form is a tangible. Secondly, following the approach of the Court of Justice in Lavola, that is the taste of food case, which you will have read about in the skeleton, the form must be one which is sufficiently precise and objective. And we say that requirement is met here. We say there is no doubt what the Bitcoin file format consists of. And that has been and can be determined objectively. Now, of course, we're at a very early stage in this case, if you permit it to proceed. But the evidence for that at this stage, if it is needed, and I'll come to it in a moment, is that others have documented the Bitcoin file format, as the judge noted in his judgment. And as we note in our skeleton, now that some defences have been filed, one of the defendants raises the point, connected with a different part of this case, that others have written computer programs that themselves can read the Bitcoin blockchain and create new blocks in that format. In other words, there's not just a single implementation of what we call the Bitcoin software, the software that operates the network of computers. There are other implementations which can and have been written. And we summarize those in paragraph 24 of our skeleton. But I don't think I need go further than make those submissions at this stage. Those are two factors which we say support the proposition that sufficient precision and sufficient objectivity is met. Our third proposition is that there is no requirement that an author provides an explanation for the work in question, allowing others immediately to read and understand it. And we say that follows automatically from the definition of writing in section 178, which I showed you. It includes any form of notation or code. There is no requirement that the public can decipher the notation or code. We give some examples illustrating the point in our skeleton, but one is an author who writes a book in a code known only to the author, or in a secret form of handwriting, Leonardo or something like that. It couldn't seriously be suggested that that work has not been fixed. It may be fixed in a form which only the author at the time can decipher, but we submit it is nonetheless fixed. It will become useful when others can decode it. But so far as subsistence of copyright is concerned, it's fixed. And another example, not in the skeleton, is the case that we see in court regularly, the case of dictation or recording of pieces of text. If the text is transcribed into English as it is spoken by a transcriber, the person making the transcription fixes the work and copyright subsists. And that follows from the provisions of section 3.2 and 3.3 that I showed you, that it doesn't have to be the author who makes the transcription. Be anybody. But we would suggest that it must follow from that copyright would also arise if the person making the transcription recorded it not in plain English, but in a shorthand notation, even a shorthand notation of their own devising. Providing the shorthand notation was sufficiently precise and objective, it would record the words of the orator, which the orator may have thought up overnight while preparing the speech. In the intangible form, they are recorded and fixed in the shorthand notation. And the last point is that copyright protects published and unpublished works. So there's no requirement that the public at large even knows of the existence of a work, let alone decipher it. So we say those conditions are met, but if we're wrong on that, and this is our fourth reason, if we're wrong on that, and that something more is required than simply moving the work from the intangible creation of the human mind into a material form, such as an accompanying explanation of some sort. And that was met in this case by the fact that at the same time as releasing the Bitcoin blockchain to the public, kicking the system off, the source code for the Bitcoin system was also publicly released. And anyone who wants to understand what the blockchain consists of can inspect both the ever-growing blockchain and review the source code if they wish to see how blocks are written and read by the software. So if an explanation is required to accompany or associate itself with a fixation, the Bitcoin software is, we say, an explanation of that kind. And to give you an example, let us suppose that instead of doing the Bitcoin blockchain in the way that it has been done, just once at the beginning, someone wrote down an explanation of what it was, just saying, this is this, this is that, that would be an explanation which would be equivalent to embedding within the file itself, preceding each field, a description. We say description isn't necessary, but if it is, a description is available in the form of the source code that was released to the public. And the fifth reason is that even if that isn't enough, the claimants can rely as a fallback upon the fact that others have documented the format. The judge accepted, for the purposes of argument, that that was the case. And the reference in that is paragraph 25 of our skeleton, paragraph 56 of the judgment. And you'll appreciate the hearing before Mr. Justice Miller was slightly unusual in the sense it was an application for permission to serve out, and I made submissions based on instructions. But Mr. Justice Miller, in a sense, accepted those instructions for the purposes of the hearing before him. And he accepted, for the purposes of argument, that others had documented it. Now, the nature of the hearing before Mr. Justice Miller is that the judgment wasn't shown any particular examples of that. He said he didn't need it. But just for completeness, in footnotes 10 on page 9 of our skeleton, we've given 2 examples. And just so you can see the sort of thing we have in mind, and of course, this is only an application for serve out, we've included an example at tab 10 of the core bundle. And this is a document written by somebody working at the Technical University in Eindhoven. It's a working paper called Bitcoin Developer Reference. It appears that the person's a student, judging by the email address. And if one looks at page 178 of the bundle, one can see the student here in this paper has set out the structure of the blockchain in a section running from page 178 to 179. There are other details, but that's just a 4 example. You can see 178 contains the block structure, the general block structure and the header, and some details of that on 179. And then at 181, details of a regular transaction. That's a normal transaction from one person to another. And then at 185, a coin-based transaction. A coin-based transaction, as I mentioned, is the transaction whereby the miner of the particular block awards themselves a coin. It's very similar to a standard transaction, but just that there's a slight difference because the coin isn't coming from another person. So that's our third point, is that even if that isn't enough, we can rely on third parties. So those are our overall submissions.
Yes, can I just go back
Yes.
to really it's your second point.
Yeah.
And you say that the requirement of fixation is met here. And I appreciate you saying that if necessary you can rely on what third parties have done. But could you articulate a little more precisely how you contend that Dr. Wright fixed the work and when?
Our contention is that Dr. Wright fixed the work when he ran the Bitcoin software that he had written and started creating blocks in that format. He says in his witness statement, essentially there were two occasions. Perhaps if I can show you, it's in tab 11 of the he explains, and of course, if this matter is allowed to proceed, no doubt further details will need to be given. He said, at 4, I devised the file format in the course of writing the code. When the software runs and the hashing problem is solved, the software creates blocks in the Bitcoin file format, which added to the blockchain. And then he says the first block was created on the 3rd of January 2009, and that's a special one. There were issues with the software which took him some days to correct. He says the second block, now known as block number 1, which is the first mined block in the blockchain, was not created until I ran the software on the 9th of January. And therefore, he says, it was first recorded at the latest, well, either when I created the Genesis block or later. And then at 8, he says, yes, I had pre-release versions. And each time I did that, it would have created a file format, but the file format would have evolved. So essentially, he's dealing with the problem of fixation that commonly arises in relation to books. And you say to an author, well, when did you finally fix the format of your book? And the author says, well, it took me 2 years to write. I went through many drafts. At some point between the start of my drafting process and the final version, which I've released to the publisher, there will have been earlier versions of it. But
we don't need to get involved.
We don't need to get involved in that. But he says the latest is, or the time at that point, is when he fixed it, was when he ran the software in early January after releasing it. Because at that point, the software was complete, the code was released to the public. And it's certainly no later than that from his point of view. So our proposition is that is when he fixed it. He fixed it by causing software, which he had devised, to start creating blocks in the format of the Bitcoin blockchain. Now, if that isn't enough, then we rely on the later fixation by others, but we say that alone is sufficient for the purposes of the law.
Thank you.
Now, the nature of this question is somewhat unusual, since it hasn't been discussed in huge detail in the earlier authorities. What I'm proposing to do is to deal with matters now roughly in the order I set out in paragraph 29 of my skeleton. And I'll take these as briefly in some instances and a little bit more slowly in other instances. And what we say is that in each case, these support the 5 propositions I've put forward. So if I may begin, and again, I'll work from the skeleton. The authorities are in the authorities bundle. The first is the fundamental, one of the fundamental conventions, which is the Berne Convention. That's in authorities.
Right first time. Berne is
the first.
The foundation.
The foundation. A9 is the authorities, and Article 2 of Berne, which has been the subject of negotiations over many years, gives a wide definition of literary and artistic works, And we're not here concerned with that. For the purposes of argument, it is to be assumed that we satisfy the requirement that it's a literary work. Article 2.2, it says that it's a matter for legislation in the countries of the Union to describe what's needed in particular any particular categories of work as to what the requirement for fixation should be. And the reason for that is that some countries consider oral works can be protected without fixation, others don't. The United Kingdom has adopted the fixation route. But what we draw from this is that the requirement for fixation need not be considered to be onerous or difficult. It's still a requirement, but no reason to suppose it's onerous or difficult. At the top of page 12, we set out two passages from a well-known textbook by Professor Ricketson, who's Emeritus Professor of Law at the University of Melbourne, and Professor Jane Ginsberg, who's Professor of Literary and Artistic Property Law at Columbia Law School, incidentally the daughter of Supreme Court Justice Ruth Ginsberg. I'm afraid I've given you a false reference at the top of page 30 of the bundle of my skeleton. It's not section 8.17, it's 8.18. Apologise for that. They make the point I made in opening. A work may just as readily be expressed in a spoken as in a material form, although this means that the work has only a transient existence. So they're making the point that the work is the work, not the fixation. And then in a later paragraph, they put forward a justification for the fixation requirement, and they suggest that the principal reason for retaining the need for fixation is evidentiary. It's hard otherwise to prove the fact of existence of an unfixed work. Likewise, it's difficult to be sure of the scope or content of the work. And therefore, 33, we make these three submissions. Fixation's not mandated, which indicates it does not need to be an unduly technical requirement. As a matter of Berne Convention, the justification is evidentiary, and we say that's consistent with the ruling of the Court of Justice in the Livola, and from that we draw the proposition that there's no need to make it an unduly difficult hurdle to overcome. In the next section of my skeleton on page 13, I've just summarised TRIPS and the WIPO copyright treaty. I needn't look at those. They're just there for background. And next, the Information Society Directive. So this directive
is notable for what it doesn't say rather than what it does.
It's had a surprisingly wide effect, it might be said. It has had an effect.
The Commissioner thought you could harmonise copyright law purely by granting exclusive rights without defining any of the contents of those exclusive rights. So we have an exclusive right of reproduction granted to authors in respect of works without defining who's an author or what constitutes a work. Unsurprisingly, this left the courts with a bit of a challenge to fill the missing bits of the legislation.
Yes, and it's a challenge no doubt this court will meet in years to come when other cases come before you trying to claim copyright in all sorts of things, probably not food, but particularly industrial designs and shapes of articles. It is going to cause difficulties for the courts of member states. But there we are, we have it. We just draw attention to a couple of drafting points. Sub-Article A gives the exclusive right, as my Lord Justice Arnold says, undefined, but some sort of exclusive right to authors, for authors of their works. No requirement for fixation built into that. B, for performers, fixation built in. C, implicitly built in because a phonogram is a physical thing. And D and E, fixation is built into those two. We've included next in our skeleton an extract
Well,
from...
yes, but isn't the significance of the references to fixations in B to D, B to E, is that that is the subject matter of the right. So you infringe a performer's performance by copying the fixation. You don't infringe by copying the performance. Likewise, a phonogram. You infringe by copying the phonogram, not the sounds embodied within the phonogram. First fixations of films. This is what was completely misunderstood by the UK when it transposed all the provisions in the directives about films. It didn't appreciate. It was talking about copying the fixation, which is something completely different to the audio-visual work, which is embodied in the fixation. Same for broadcasts. So the significance of the reference to fixation there is it's the subject matter you're protecting. It's not talking about conditions precedent to protection in the first place.
Lord, if I may say so, absolutely. The nature of copyright in a cinematograph film is in the recording, the film itself, not in the play or plot of the film. It's a different type.
That's because it's protected under A.
And that's because the plot is protected under A. But A doesn't include in terms a requirement for fixation, although, as we'll see, the Court of Justice has implied some form of requirement for fixation. But so far as EU law is concerned, it's not mandated in term.
Well, but the point is this. I mean, before we get to what the Court of Justice has said, what would you say to the proposition that, so far as Article 2A is concerned, the position adopted by the directive is consistent with Byrne? That is to say, it neither mandates fixation nor prohibits fixation, it leaves it to the member states. In other words, fixation of works is not harmonised one way or the other.
Yes, that might be the position that the Court of Justice in due course takes in the EU. Equally, the Court of Justice might say that...
Well, they might say there's an implicit harmonisation.
They might...
And implicitly there's a requirement of fixation.
Yes.
And it may be, as you suggest, that is the correct reading of Livola. But if we just takes the legislation on its face before one gets to Livola, one might say it's just simply neutral.
It could be said to be neutral, in which case one would just revert back to the UK Act itself and the wide definition of writing, meaning any form of notation or code. Yes, so at 39 we've included an extract, the full extracts at tab 12 of the authorities bundle in Michel Walter and Suki von Lewensky's book. Professor Walter is...
But they're simply drawing attention to the first point. Right?
Yes, they are.
Which is that what's protected is the work, not rather than the fixation of the work.
Yes. Yes, exactly. But what they do say is that in the middle of the passage I've set out at the bottom of page 14, it doesn't distinguish, referring to Article 9.1 of the Berne Convention, doesn't distinguish between the first fixation of a work and its further reproduction, nor is a differentiation made between the original of a work and copies thereof. So the point that they make is that the first fixation of a work is essentially the first reproduction of the intangible work. And that reproduction right is the exclusive right of the author. So in a sense, they're equating fixation to reproduction. Now, that analysis, which we submit is correct, means that it would be an odd result if creating a block, which inevitably reproduces the Bitcoin block file format, and then including it in the Bitcoin blockchain, so that for practical purposes it's fixed for all time, were not to be considered to be a sufficient, were to be fixation. It's the reproduction of the work, the intangible work, embodied in the first reproduction of that, which is the first time a block is created in that format. But going back to my Lord Justice Arnold's point, absolutely, at this point in time, the Information Society Directive is neutral as to whether fixation is needed for protection under sub-article A. The next case is Livola, and it's probably easier if I take you to that in the authorities bundle, because while I set out extracts and Mr. Justice Mellor set out extracts, it's probably useful to see them all in context. So tab 3 of the bundle, page 28. And it's a judgment of the Grand Chamber of the 13th of November 2018. And as is conventional with the judgments, and I won't dwell on them, page 29 of the bundle, paragraph 3 onwards, the court sets out international law, the Berne Convention, later on TRIPS and the WIPO copyright treaty, which I mentioned. At page 30, it sets out the Information Society Directive. And then, so the background is essentially the same background as I've addressed you on. If one jumps to page 32 of the bundle, paragraph 14, one can see that the case was about a spreadable dip containing cream cheese and fresh herbs, which was created by a Dutch retailer of vegetables.
Yes, well, that was the specific facts of the case, but it was against a background of controversy across the EU as to the extent to which copyright protection is available for some things that were perceptible through senses other than sight in particular. So this is about taste.
Yes.
But the same issue arises on smells of perfumes.
Yes. It's an important point as to what the boundaries of copyright protection should be, a problem created in part by the very broad wording of the Information Society Directive. But absolutely. If one looks at page 34 then of the bundle, paragraph 32, the Lord Justice Arnold has indicated the question was a much more abstract question, is does directive preclude the taste of a food product, any food product, from being protected by copyright and preclude national legislation being interpreted in such a way as to grant that copyright?
So part of the problem is that the question referred is at root about the interpretation of the definition of literary and artistic works in Article 2.1 of Berne.
Yes.
And the reason why the Court of Justice has jurisdiction over that question is because the EU is a signatory to Berne through TRIPS, in effect. Not directly.
No.
That's effectively where it comes down to. But the question is not actually about fixation.
No, it isn't. It isn't about fixation. It's about what a work is.
Yes. Which is one might have thought is a prior question.
Which is
logically.
Which is a prior question, but as one can see, it merges perhaps into the question of fixation in the way the court has dealt with that particular problem. It's not, but absolutely, if one were to answer the question, the question is simply, is the taste of a food product a work, yes or no? That's the question. And if national legislation were to say that it could grant copyright protection to that, is that national legislation precluded from being interpreted in that way because of the existence of the Information Society Directive?
Yeah, and the answer given at paragraph 44 is no.
Yes.
But the answer given is it's not a work.
Yes. Yes. So the analysis of the Court of Justice, it's quite interesting to see how they get there. At 33, they say that we have to give an autonomous and uniform interpretation of the concept of work. So that's their starting point. Work moves from the domain of member states into a question of EU law. Member states must stick to an autonomous and uniform interpretation. So then the logic follows in 34 that to be a taste, to be protected, it has to be a work. So far, so good. At 35, they then say two conditions must be satisfied. One is that it has to be original, not an issue in this case, and very conventional. It must be original in that it's the author's own creation. And secondly, it's got to be the expression of that creation. And then in 38 and 39, the court explains the difference between expression, which is something capable of protection by copyright, and if one looks at the last three lines of 39, copyright protection may be granted to expressions, but not to ideas, procedures, method, or operations. So that's the expression-ideas dichotomy. So those are the two fundamental requirements. But then the crucial point, and this is where the reasoning is very interesting, is they then say, for a work to be protected, it must be expressed in a manner which makes it identifiable with sufficient precision and objectivity. So the Court of Justice doesn't, in terms, talk about fixation. What it simply says is you must express it in a manner which is sufficiently precise and sufficiently objective. So our proposition is that that is met in the case of a work in the UK, which is fixed under our provisions, because if it's fixed under our provisions, it is identifiable with sufficient precision and also with sufficient objectivity, because anybody can go and look at the fixation and say, yes, I can see exactly what it is. And the reason the food product fails is at 42, you can't pin taste down with sufficient precision and objectivity. And at 43, rather alarmingly, they say it's not possible in the current state of scientific development to achieve that, which perhaps leaves open later cases when some technical means can be developed. Absolutely, it's not a requirement for fixation. It's a requirement for sufficient precision and objectivity. But we say if something is fixed in the UK sense, it is, and in the facts of this case, it is fixed with sufficient precision and objectivity. The next cases are the cases my Lord Justice Arnold will be very familiar with, which is the SAS Institute cases, of which we've included 3 in the authorities bundle, just identify them. There's only a short passage from each which one needs to look at. At tab 4, there's my Lord's first instance decision. At tab 5, there's the reference to the Court of Justice. And at tab 6, there is my Lord's decision when the case returned from the Court of Justice, and various arguments were developed from that. Now, if I can compress our submissions on that to 2, the first comes from tab 5, the Court of Justice decision, at paragraph 45, which is at page 179 of the bundle. the case concerned principally the question of whether copyright protection should be afforded to, the jargon, the functionality of a computer program, what it does, rather than the code for the computer program, the work that describes the computer program and implements that functionality. But there was an issue about the question of a file format, and at 45 the court says the finding made in paragraph 39, that's dealing with functionality, can't affect the possibility that the SAS language and the format of SAS Institute's data files may be protected under the Information Society Directive. The proposition we draw from that is simply there is no in principle objection to copyright protection for a data file format. There may be other conditions that have to be met, but there is no in principle one. The second point, just to deal with it, but it doesn't arise in this case, is the question of whether a computer program itself may be a sufficient fixation of the file format. If a computer program can read and write from files, could it be said that somehow automatically that is a fixation? We're not relying upon that proposition, to be absolutely clear. But if I can just direct you to a passage of my Lord Justice Arnold's judgment at page 75 of the bundle, tab 4.
Sorry,
I do apologise.
no, my fault. Tab 4.
Yeah, yes, tab 4.
I've gone on to tab 6.
Yeah, sorry. So you were at tab 6. No, it's my mistake. So tab 4 is the first instance decision.
Yes.
Perhaps I ought to just show you a finding of fact first, which is tab 4, page 54, paragraph 23. And here, Lord Justice Arnold was dealing with the question of whether there was evidence that the format of the file was fixed within the source code for the SAS Institute product. And if I can just take up the last paragraph of paragraph 23, that evidence was capable of seriously misleading a non-technical judge. There is, in fact, no evidence that the SAS source code does detail the relevant SAS data file formats, as opposed to reading and writing files in those formats. So in other words, it is not impossible that source code may amount to a sufficient, if you like, fixation of a data file, but it is highly fact sensitive and would require analysis of the source code, and we're not relying on that for the purposes of this case. And then that's picked up in the judgment later on at paragraphs 128 and 129. And at 129, counsel for SAS Institute submitted that a particular example demonstrated that world programming had copied elements of the SAS code into the source code of WPS. In my judgment, it shows nothing of the kind. All that it shows is by examining the SAS system in operation, World Programming Limited worked out enough of the format of the SAS data files to be able to write files, able to write code which reads and writes from those files. So in other words, it's just emphasising the point that one can't say the source code is a fixation of the data file format, although, of course, it may provide a strong guidance as to what the data file format consists of.
Of course, that wasn't the issue at that stage.
No.
The issue, as you can see from the extract at 129, is that there was an allegation of copying of the source code.
Yes.
And that was completely unfounded.
Yes.
Because the mere fact that you could read and write data in that format didn't begin to show that there was any reproduction of the source code at all.
No. So SAS Institute was a decision on the particular facts. The important point...
Yeah, I think the judge, in our case, was more worried about what I said in the second.
Next time round, yes. Yes, when I appeared in front of your lordship on the return, which is at tab 6, yes, the judge was more concerned about that. And so I just lost Yes. So the case has now been to the Court of Justice. SAS Institute had picked up on that passage I showed you and attempted to, perhaps if we can put it this way, recast the case.
Yes.
Recast the case on the basis that, well, if we can't protect the functionality of the software, nevertheless there is sufficient evidence and material produced at the first instance trial for us to be able to pursue an allegation of infringement of copyright in the SAS data file formats. And at 37, my lord said, SAS Institute can't advance a case. They are distinct copyright works without pleading it. A pretty fundamental problem, there was no amendment yet formulated, but it would, in conventional terms, require new factual and legal issues to be addressed. And then Arnold points out that there was relatively little evidence at trial, and then you refer to paragraphs 128 and 129. And then at 39 you say it's the question of whether it's a work is not straightforward. To some extent that may now have been answered by Lavola as to what the requirements for a work are. But at 40 you point out even if it is a work, it raises the question of fixation for the reasons given in my first judgment, and that's a typo. It should say 23 rather than the 32.
Yes.
It's not established that it's fixed in the SAS components or the SAS manuals. And that was important because the pleading of copyright infringement was that the file was based upon two things, the program itself and the manuals. So the fact that there was no, what SAS Institute was arguing was, oh, well, don't worry that we haven't pleaded it. We've alleged copyright infringement in the SAS system itself, those are the SAS components, the software itself, and copyright infringement in the manuals, but there's no evidence that the file format is fixed in either of those two. So certainly fixation was a concern, but it was a concern that there wasn't evidence that it had been fixed in those two particular things that were relied on, the software and the manuals. This case is different because we're relying upon the fixation in the file itself. And in subsequent documents that others have produced if we need to. So that's the SAS Institute. So we say with respect to the judge, his concern over SAS was, with respect, misplaced. SAS was a decision on its facts that it was much too late for SAS Institute now to advance a claim for infringement of copyright in the data file format. And particularly so since the only pleaded copyright works were the computer program itself and the manuals that were written. Now, the only other two cases in the UK that deal with the subject of data file formats are Technomed and Software Solutions, as far as I know. And these have been discussed by the judge in paragraphs 41 to 48 of the judgment. Now, if I could just summarise our propositions in relation to those, and then just look at a little bit of detail. Both these cases concerned data files stored in XML, extensible markup language files. Now, XML is a widely used system for storing data these days. It's not particularly space efficient, but it has other advantages, which are that it's machine readable and to some extent it's also human readable. And it's a very simple format which can be widely adapted to create your own format, if you like. But an important characteristic of it, it includes what are known as tags, which are brief, can be brief descriptions of the content following. And if I could just give you an example to illustrate, doesn't jump out particularly clearly from the judgment, but if I can just give you an example of our understanding, is that if one was storing a list of patient data for a hospital, you might want to know the first and last names of the patient and the date of birth and the date of the last visit and the name of the doctor and the details of any allergies the patient might have. And the way that XML works is that one indicates where in the file a particular piece of information is going to be stored by including before and after the data things called tags. And so one might have a tag called first, and conventionally one sticks it in angles brackets, and you say first, and then you stick the first name of the patient, and then you conclude it with another tag, which is the closing of first. And you have another tag which says second, the second name, and so on. You can think up any name you want, but in a sense you document for yourself what the file is consisting of so that somebody can pick it up quite easily and read it, if you understand what is happening. I say quite easily. It would require a certain level of technical ability, but it is to some extent self-documenting. Now, in probably the easiest place to see where that is summarized is in paragraph 108 of Technomed, which is tab 7, page 251. Now,
pardon, could you give me the paragraph reference again?
Sorry, paragraph 108.
Thank you.
Actually, probably easier just to go back to paragraph 107. Technically, the issue we're considering today didn't arise because in the preceding paragraph 107 there was reference to SAS Institute, and it was accepted on behalf of the defendant that the XML file format could be a literary work so long as it meets the intellectual creation test, and therefore don't need to resolve the concerns raised about fixing. So the case is not about fixing, it's about intellectual creativity. Of course, defendants in this case, if the case is allowed to proceed, may raise that as an argument. And then at 108, perhaps if I can just invite you to read that, 108 and 109. And the point is that what was highlighted were the names chosen by the scheme designer, the collection of names. And I gave you an example. The names might be first, last, allergy, doctor, and so on. The collection of names was relied upon. The witness wasn't cross-examined. And the submission was that the XML file format contains content, not just structure, and hence is entitled to copyright protection. But that submission was in the context of intellectual creativity, and it doesn't appear to have been contested particularly strongly. It was not accepted, but there was no cross-examination on the process that was involved, which was thinking up names. So we say software solution is not a decision on what fixation is about.
That's Technomed. Software solutions is the next.
So it's my mistake. I've given you the wrong lesson. It's Technomed. Technomed is not a decision on fixation. It's a decision on intellectual creativity. And yes. So if one can look at how the judge deals with software solutions in his judgment, that's...
Shall we look at software solutions itself?
Yes, I do apologise. Yes. Yeah. So the description is at page 267. It's about XML files, But the important point is that it was accepted in this case that copyright subsisted. It wasn't a case about fixation. It was a case about XML data. But the question that we're considering today...
Yeah, so as I understand it, the point you're making is that if we look at paragraph 6, sub-paragraph little Roman 2,
Yes.
we see that it was a common ground that copyright subsisted in the XML schema as a literary work.
Yes.
And therefore the issue simply didn't arise.
It didn't arise. So neither of those two cases decide the point you need to consider today. And with great respect to the judge, we say the judge was misled, in a sense, into thinking that because XML files are protected, conceded in those two cases, because they do contain content indicating structure, that's a necessary requirement. It's the other way round. They would be protected anyway, but an additional factor that one can rely on when considering intellectual creativity is the fact that the names given to the data fields may themselves involve a level of intellectual creativity. So those are our submissions on the cases, and in a sense our submissions on where the judge went wrong are quite simply the judge misunderstood the requirement for fixation. As a matter of UK law, it merely requires a form of code or writing. If one wants to introduce European concepts, it merely requires sufficient objectivity and precision, which is met in this case. And there is nothing in the Berne Convention or in the Information Society Directive which points this court, at least for the purposes of service out, in a different direction. So those complete the submissions I want to make on behalf of the claimants in this case, unless there's any further questions.
No, thank you. We're extremely grateful, Mr. Hicks, and for the clear and helpful way in which you have conveyed these difficult concepts. So thank you very much. As you'll appreciate in this court, the way things that happen is that a draft or drafts will be circulated, and they must only go to the nominated people at the addresses which have already been given, and we take the embargo extremely seriously, and you'll appreciate that and realise that there have been difficulties lately about that. So when the drafts or draft comes out, please make sure that the embargo is honoured. And then there'll be an opportunity to provide us with a list of typos, but not to readdress argument. And consequential matters, well, it'll be easy in this case, no doubt, but will be dealt with on paper, as you'll appreciate also. And we'll get to that as soon as we can. So thank you very much indeed.
All rise, if able.